The Judicial Service Commission will today hold interviews to fill vacancies in both the Labour and Electoral courts. In fact, one candidate, Judge Leicester of the Gauteng High Court in Johannesburg, will be interviewed for a vacancy in the Electoral court, while 4 other candidates will be interviewed to fill 3 vacancies in the Labour court. The April leg of the JSC interviews will only sit for 1 day and is expected to begin this morning at the CSIR International Convention Centre. That's in Pretoria. In fact, some of that has already started, and we're going to show you live visuals now from inside that particular convention centre. You can see the final preps, if you like, dotting the I's and crossing the T's before these interviews finally begin in earnest. As mentioned, Judge Adams from the Gauteng High Court in Johannesburg said to be interviewed for a post in the Electoral court, while 4 other candidates for posts in the Labour court. Crucial to watch this, by the way, given just how often we've spoken about a lack of capacity in some of the country's courts. I mean, we've heard of delays, for example, in the High Court until the year 2030. In other words, if you wanted to litigate in Johannesburg's High Court, you have to wait that long before your case can finally be presented. And whilst these kind of interviews obviously are crucial, there is another aspect in the value chain, for lack of a better word, which involve actually hiring judges and bringing them into the fold to fill the other vacancies. Let's dip in for a while, take a listen to how this is all started.
Thanks, DP.
Thank you, CJ.
Candidate colleagues, Minister.
Thank you very much. Good morning, CJ. And let me just welcome Judge Adams and wish you well in this process. Let me just start by asking, in 2015, the Constitutional Court criticized you for failing to inquire to the relevant circumstances of the evictees at that time, refusing to rescind the original eviction order that was erroneously granted. And in this, because I'm just, as you know, I'm former Minister of Human Settlements and would have had to deal with the plight of those that are evicted, when they are evicted, a majority of them being women and children. In that regard, and I do believe that this would have put this vulnerable group at risk in terms of not being able to be having a shelter over their head. Do you regret this decision that you took and your exercise in terms of good judgment in this regard?
Yes, thanks for the question, Minister. As indicated, I think, by the GCB, that judgment was handed down very early on in my career on the bench. I was acting at the time, firstly. And secondly, I most certainly have learned from my judgment. In the context of the development of the law at the time, I clearly erred, as was held by the Constitutional Court. And with the benefit of hindsight, I definitely will deal with the matter differently now. The matter was referred back to the Johannesburg High Court, and I'm told that subsequently that matter has been resolved favorably in favor of everybody, including the owner of the property.
Thank you very much. I think the next one that I have, just last one, CJ, it's around the modernization of the voting system. That IEC would have announced that investigating electoral voting to modernize South Africa's elections. And some have argued that there are what e-voting offers a wide range of benefits in terms of that. But there are also those who are arguing around the downside of the digital electoral process. Issues such as tampering and not making sure that there's actually the right to vote by many, especially those that are in rural areas, but also potentially of ensuring hacking of the systems, cyber crimes, that could lead with tampering of the votes and democracy in our system. What is your perspective in this regard in terms of the integrity of our electoral system by the introduction of digital platforms or digital voting, and whether that could tamper with the right to vote or even one vote, one citizen across the country?
Yes. Thank you, Minister. I think it's inevitable that at some point we need to progress towards digital and e-voting, but we must obviously be alive to the risk involved. I think the Electoral Commission has commenced the process in the registration of parties and candidates must be done electronically, but they have also retained the option to do some of these processes manually. I think there are risks involved in the digital voting process, but I think similarly it has its advantages, and maybe that's ultimately the way that we should progress.
Minister, any more questions for the candidate colleagues? Professor Marumachai?
Thank you very much, CJ. Good morning, Judge.
Morning, Prof.
Judge Adams, I want to ask you a question. I think in the last round of interviews for this court, one thing that concerned me, not in relation to you, but generally, was that it appeared to me that there were some candidates who were not quite familiar with the recent developments in the electoral law or election law, as perhaps you put it in your question. I just want to ask you, I want to satisfy myself that you have been acting for a year, that at least you are vested in the development. I'm not sure if you are aware of the amendments that were done in 2003 to the Electoral Act, and some of the requirements in relation to candidates who wants to stand outside the party political structures, and some of the concerns that they had. I want to find out from you, what were the major concerns and how did the Constitutional Court try to address those issues?
Yes, thank you, Prof. I think that the main concerns that the independent candidates had related to the requirement that they needed to have a 15% of the quota of voter supporters to just get onto the ballot, so to speak. And they thought that that was unfair, firstly vis-a-vis the fact that they don't have the necessary capacity to do that. And in fact, they had to do that. If you're going to be standing in any particular province, you needed to get 15%, and which 15% of voter supporters of the quota from the previous elections. So in certain instances, for example, that would have required them to get about 14,000 signatures, names, identity numbers of supporters. And so the Constitutional Court agreed with the independent candidates and said that that seems unfair, and they reduced that and said that all that they need is 1,000 voters for each particular province or each region that they're going to be standing in.
Thank you, Prof. Commissioner Malem?
Thank you very much. Judge, just a follow-up on the last question. What mechanism can we put in place to verify that these 1,000 signatures are authentic? Because they are not being audited anyhow. Yeah. We just get a name, surname, correct ID number, and then you sign or get different people to sign for other people. How is that helping us if it cannot be somehow verified that these are authentic signatures?
Yes. Thank you, Commissioner Malema. In fact, that was exactly the difficulty that the Electoral Commission had in the Liebenberg matter. I don't know if you're familiar with the matter, but it's Liebenberg versus the IEC. Mr. Liebenberg intended standing independently in some of the provinces, and the Commission has systems in place that is able to verify, firstly, the ID number. They connected somehow to the Department of Home Affairs, so they were able to make the connection and see and verify, firstly, the identity number. And then, so if it's a non-existent identity number, it's thrown out automatically. And then they also have a way of establishing the residential addresses of these persons. And that they got from their systems that indicated that a particular person is registered in a district. And in this case, for example, in Limpopo, when there was an attempt to have them used as a supporter in Mpumalanga. And so they were able to pick that up. And ultimately, they then also had investigations done in respect of certain individuals who then confirmed, for example, that they were not the ones that signed those